All start. Please be seated.
Good morning. This is the Supreme Court of Solaria session now. Today again between US for refugees and OARA, the Organization for Refugees and Returnees. My name is obviously the president in charge of this session. My left is Judge Mizani and Judge Wolge. On my right we have Judge Multaab and Judge Aizenam. I think both parties are present, as we can see from the situation. You're going to have 27 minutes for presentation of your case, both the applicant and the defendant. You can allocate your time amongst yourself. Yeah, you can also reserve 7 minutes for your rebuttal, if you like. And we will start with the applicant. Just introduce yourself and go to your case. One minor change from the past 2 days. We're going to have interjections in the middle of the presentation, so questions may be raised. So prepare yourself for questions and answer in the middle of the issues. Your time is going to be maintained accordingly, and we can reserve that. And the time is to the applicant now to present their case.
Thank you, Honors. Good morning, Your Excellencies. This is Mr. Gada. Today we appear as an applicant representing the lawyers for refugee rights, and we have attached our certificate of representation with our submission. Today, the applicant will submit 9 pleadings, and the first 3 pleadings will be addressed by me, and I will be using 7 minutes. The following pleadings will be addressed by my co-counsel, Mr. Basukad, and he will be using 8 minutes, and the last pleadings, including the prayer for relief, will be addressed by Mr. Basukad Shmi, and he will be using 7 minutes, and we have reserved 5 minutes for rebuttal. Thank you. Your Honors, if the court grants us the permission, we'd like to use some words in abbreviation, please.
You grant.
Thank you. Before proceeding to the pleadings, would you like a brief summary of the case, or let us proceed just please?
You can proceed with your
All right, thank you. May it please the court, so I'm an answer to my first submit. For 2 reasons, the decision of ORA, Office of Refugee and Return Affairs, rejecting the application of asylum of refugee from Russia constitute an error of law. The first reason is that the refusal of the state of Solaria to grant a refugee status for Russian asylum seekers, contending that they are climate migrants and does not fulfill the requirement of the definition of refugee, is inconsistent with its international obligation. Russian asylum seekers flee to Solaria because of unprecedented flooding, and this flooding put much of Russia underwater and destroyed many crops. So they don't have any other option rather than fleeing to Solaria. So this falls strictly under the spirit of Article 1, Sub 2 of the 1969 OAU Convention, and as well as Article 5, Sub 1, C of the 2019 Refugee Proclamation of Solaria. As the asylum seekers flee to Solaria because of a serious event, and this serious event which brings or results a serious disturbance in public order. And Your Honor, in addition to this, the government of Russia was not in a quite adequate position to provide any support and protection for the Russians. So because of this first reason, the decision of ORA rejecting the application of asylum of refugee from Russia constitutes an error of law. The second reason is that the refusal of the state of Solaria to grant a refugee status for asylum seekers, contending that it is impossible to distinguish between those who are claimed as migrants and those who flee to Solaria because of conflict-related persecution is inconsistent, is in breach of its international obligation. The asylum seekers from Russia flee to Solaria not only because of a disastrous climate change or natural hazard, but it was also exacerbated by simmering conflict and violence, which was a man-made disasters. So the 1951 Refugee Convention, and as well as the 1969 OAU Refugee Convention shall apply in this scenario. What we want the court to uphold is that asylum seekers from Russia should have been benefited from the principle of benefit of doubt. May it please the court, so I'm an author to my second submission. The second submission will be the refusal of the state of Solaria to grant a refugee status from Russia who flee to Solaria because of gender-based violence, particularly female genital mutilation, is in breach of the international obligation, is inconsistent with the evolving jurisprudence. ORA does not accept the asylum seekers from Russia who flee because of FGM, contending that the persecution that they are complaining does not fall under the grounds of the convention, which are race, religion, nationality, being a membership of a particular social group, or political opinion. But your honors, at the same time, ORA forgets the fact or ignores the fact that being subject to female genital mutilation may be attributed because of being a membership of a particular social group or political opinion or religion. And also, this was affirmed by the fact paragraph 6, which was even their families support this practice. And so this shows us that the social group that the girls were engaged in have a common characteristics or attribute regarding this female genital mutilation or regarding this practice. And we have also an instant case which was decided in UK between Forna and the Secretary of State for Home Department, which Mrs. Forna was granted to refugee status because of persecution of fear of FGM. FGM is a form of persecution, and it is affirmed by the development of the regional and as well as international human rights instruments. And also, it consists of torture, inhuman treatment, and cruelty, which is affirmed by the evolving jurisprudence, the legal doctrines, and as well as human rights councils and European Court of Justice. So, expelling or returning these girls to a place where they will be subject to this form of persecution, particularly FGM, is in breach of Solaria's international obligation. May it please the court, so I will now turn to my secretary.
So let me interject on this particular point, specifically on the grounds that you mentioned. So specifically to the case of FGM, what ground are you presenting now that
this group of persons must be protected? You have said about particular social group, you have said about religion, you have said about political opinions. So in this specific case, which is the ground that you want us to use in terms of interpreting the convention?
Relating to the grounds, particularly we want this court to focus on the term being a membership of a particular social group, and we can also attain this interpretation from the case I previously mentioned, being a membership of a particular social group. So then actually Forna was a woman from Sierra Leone, and the being a membership of a particular social group means those who are initiated or uninitiated girls were considered as not even a woman. So in the specific in a place where this female genital mutilation is practiced, women are not even considered as a woman if they are not uninitiated or. So specifically, we want to infer to the being a membership of a particular social group, but there are also religious aspects, especially in a country like Africa, there are diversity in culture and also political opinion too, because when girls oppose or this kind of practice, the local leaders try to count it as a political opinion or.
I understand your argument, But in this specific case, so shall we also consider the political opinion of the court?
For this political...
For this hypothetical, for this particular case.
All right, thank you, Ron. For this particular case, it's better if we just stick to the being a membership of a social group. Answer?
Yeah.
Thank you. So the third reading will be, or the third submission will be, the decision of ORA related to exclusion of asylum seekers who crossed Solaria's border in stolen cars back to their country of origin constitutes an error of law. The refusal, the rationale for exclusion clause should be in mind that when considering this application, is that certain acts are so much grave as to where the perpetrators are deserving of international refugee protection. The 1951 Refugee Convention, Article 1, Sub F, excludes persons who commit serious non-political crimes against humanity, and acts contrary to the purpose and principle of United Nations. So, according to this scenario, to this specific case, the asylum seekers labeled as fugitive from justice, which are labeled by ORA fugitive from justice, does not fall in this ground because the asylum seekers from Arcadia stole the car to avail themselves from a conflict or a sibling conflict which is in Arcadia. So it is clearly affirming the fact that there was no any kinds of method or to avail themselves from that conflict. So they stole the car because of that. And therefore the action of the asylum seekers was a petty theft, which is not an armed robbery. It's not an armed robbery. So because of this, as there was no violence, any kinds of violence, which was taken to stole the car, they stole it from a parked region, and this does not fall under a serious crime, but minor crimes, and this can be obtained from the UDHR guidelines, paragraph 14. And in addition to this, Solaria has breached the principle of non-refoulement, which is pursuant to Article 33, Sub 1. All refugees are entitled to be protected from refoulement, and this includes even those who doesn't even acquire the status of a refugee. And Solaria had clearly breached this principle. In addition to this, Article 3 of the United Nations Convention Against Torture and Inhuman Degrading Treatment, and also Article 6 to 7 of the ICCPR shows that if you state, even for criminals, there should be a complementary protection, and they should not be exposed to a place where they will be treated to their life and inhuman treatments. So because of this, the decision of ORA relating the exclusion of asylum seekers who crossed Solaria's border in stolen cars back to their country of origin constitutes an error of law. May I please the court, if there are no any clarification to the address, I will invite my co-counsel.
Honorable President Judge, Your Excellencies, may I please the court? I will be addressing the next four pleading, starting from the third one. The decision of ORA to withdraw the refugee status for several Arcadian refugees due to still circumstances in Arcadia constitutes an error of law. If there is a sufficient level of well-founded fear of persecution for a person, it is good enough for him to be considered a refugee under the International Refugee Convention. This fear of persecution may, however, disappear, resulting in cessation of the refugee status for the person concerned. However, the case at hand, under the facts of the case, paragraph 5, line 4, under the additional facts of the case, paragraph 5, line 4, ORA's proposed decision to withdraw the refugee status of several Arcadian citizens for the mere fact that the newly inaugurated government of Arcadia has made some promises to make reforms is inconsistent with Solaria's national and international obligation. This because it's inconsistent with Article 1, sub 5, C sub 5 of the 1951 Convention, and also Article 9E of 2019 Refugee Proclamation of Solaria. And also, to reach such a decision, states must first undertake an examination of the fundamental character of the changes in the country of nationality or origin, including the general human rights situation. However, the case of ORA set a decision forthwith without making any examination as to the fundamental human rights situation in Arcadia, and instructed the Arcadian citizens to repatriate. Furthermore, ORA's decision is in violation of Article 9 sub 1 of the Tolerant Refugee Proclamation, as ORA ordered the Arcadian citizens to repatriate the country, depriving them of their right to appeal. It deprived them of their right to appeal. In addition, ORA did not accept the complaints of the asylum seekers that they should not be deprived because they had previously suffered an atrocious forms of persecution in Arcadia. Thus, is in contravention with Article 9 sub 2 of the 19th Proclamation and Article 10 of the 19th Refugee Convention. With the permission of the court, I would like to proceed to the next pleading. The issue of ORA related to the refugee status determination constitutes an error of law. As per Article 46 of the 2019 Refugee Proclamation, the government of Somalia shall cooperate with the UNHCR in exercise of its function in accordance with Article 35 of the 1951 Refugee Convention. Moreover, Article 16, sub 2c of the 2019 Refugee Proclamation states that ORA shall invite the UNHCR to participate as an observer in deciding asylum cases. However, the adversity process has been mainly handled by the UNHCR, the ORA with minimal involvement of the UNHCR. And this is in breach of Solaria's international and national law obligation. Besides, many Arcadian applicants have for so long complained that there are both standard lack of fair and efficient adversity procedure and lack of legal assistance and interpretation in the course of the application. However, ORA rejected this claim, stating or pointing to the fact that it has granted asylum seekers to its territory and readily deports them back to their country of origin. However, this justification is not acceptable, as refugees are not only entitled to the protection from refoulement, rather they have a wide range of rights. Thus, given the fact that Somalia basically denied does not directly address the complaints of the asylum seekers, and together with the systemic denial of the adversity procedure, which allowed only minimal involvement of the UNHCR, is in breach of Solaria's obligation. With the permission of the court, I would like to proceed to the next pleading. State of Somalia is forcing in summary return of asylum seekers, including unaccompanied minors from Arcadia, as well as the systemic denial of adversity procedure, is in breach of the principle of non-refoulement. The principle of non-refoulement, as prescribed under Article 33 of the 1951 Refugee Convention, is the cornerstone of international protection. It imposes on states to refrain from any conduct that can be direct or indirect that can put a refugee at risk of being returned to his former original residence or his. Solaria, however, justifies some of the restrictive measures that it took as a necessary precaution for its national security and border integrity. However, this is not acceptable, as none of the asylum seekers were found to have been convicted for serious crimes that is sufficient to trigger Article 33 sub 2 of the 1951 Convention. Solaria have also returned unaccompanied minors without making sure that they were being returned to a favorable situation for their well-being. Hence, the state of Solaria is forcing in summary return of asylum seekers, including unaccompanied minors, coupled with the systemic denial of adversity procedure, constitutes an error of law. In addition, the directive ORA adopted in January 2022 receives asylum seekers as an illegal breach its international obligation. Asylum seekers have for so long complained that they have been targets of xenophobic and intolerance toward them. And this is further exacerbated when the asylum seekers and refugees are mischaracterized as criminals, illegals, or even sometimes as terrorists. Hence, ORA's directive, which labels asylum seekers as an illegal, is in breach of its international obligation. With the permission of the court, I would like to proceed to the next pleading. ORA's directive and decision, which says only refugees who are lawfully staying in Somalia are entitled to the rights under the 2019 Refugee Proclamation, is inconsistent with its international and national refugee law. The 2019 Refugee Proclamation of Somalia vests a wide range of rights to asylum seekers and refugees. As per Article 46 of the 2019 Refugee Proclamation, ORA may issue a detailed directive necessary for the implementation of the 2019 Refugee Proclamation. However, in no way can ORA issue a directive that can take away the rights of refugees granted to them under the 2019 Refugee Proclamation. Nevertheless, the deliberate usage of ambiguous terms like lawfully staying and the requirement of regularity of same duration have negatively affected the rights of asylum seekers and refugees. Hence, the state of Solaria is in breach of the 2019 proclamation. Moreover, as can be noted from the facts of the case, Solaria has decided to shift from the care and maintenance approach to self-reliance and gradual inclusion of refugees into the national system. And it was to this effect that Solaria enacted the 2019 refugee proclamation. Under this proclamation, Article 26 vests the right to work on asylum seekers and refugees. However, paradoxically, Article 20 of the Directive number 60/2021 issued by ORA states that Solaria will pursue self-complement policy and care and maintenance of refugees. And this has a clear repercussion on the right to access to work and education, as it will confine them to campus or otherwise restrict their residence. And it's also inconsistent with the CRRF, or the so-called Comprehensive Refugee Response Framework, and one of the 9 plays made by Solaria. Now I would like to invite Mr. Friedrich to address part of the opinion.
Honorable Presiding Judge and Your Excellencies, may I please the court? My name is Friedrich-Ebert, and I will address the remaining pleadings, including prayers for me. As regards the AS1, the decision so far relating to the standard of treatment is a treatment that, according to aliens, generally constitutes an error of law. Your Honor, Article 26, sub-Article 2 of the 2019 Refugee Proclamation of Solaria clearly affirms the rights of refugees and asylum seekers is based on the standard of most favored foreign national treatments. Apparently, as it can be inferred from paragraph 18 and 19 of the fact of the case, aliens generally are not the most favored nationals in Solaria. And conversely, foreign nationals of Solaria origin, or FNSO, is a most favored nationals in Solaria. However, the requirements of work permit and the restrictions of to only engage in a place where open for foreign nationals under 18 first under Article 19 sub-Article 1 of the Directive number 16/2021 of Solaria is an indication of that directive considers that neither FNSO or foreign nationals of Solaria origin or Mycenaean nationals to be considered as most favored nationals in Solaria. Thus, the directive has not provided a clear implementation of the proclamation of Solaria, particularly Article 26 sub-Article 2 of the 2019 Refugee Proclamation of Solaria. Therefore, the decision so far relating to the standard of treatment is a treatment that, according to aliens generally, constitutes an error of law, and it is inconsistent with Solaria international as well as national refugee law obligation. With the permission of the court, I would like to proceed to my next reading. Thank you, Your Honors. The decision so far which states that the comparator group or reference group for most favored national treatment constitutes an error of law. Your Honors, as it is noted on the fact of the case, in Solaria, there are 4 major classifications of foreign nationals. Among these, foreign nationals of Solaria origin or FNSO enjoy the best treatment. Your Honor, in Solaria, those refugees and asylum seekers wrongly complain that they are entitled to the same treatment as according to FNSO, or alternatively, they are accorded to as Mycenaean nationals. However, ORA rejects these claims by contending that it is against the law of Solaria. Nevertheless, this decision of ORA is against the international as well as the national obligations of Solaria. Particularly, it is against Article 26 sub-Article 2 of the 2019 Refugee Proclamation of Solaria. Due to this, the decisions of ORA that states the comparator group or reference group for most favored national treatment constitutes an error of law. With the permission of the court, I will have to proceed my prayer. Thank you, Your Honor. Based on those raised legal and factual grounds, the applicant humbly prays this honorable court to repeal the decisions of the appeal hearing councils of ORA and adjudge that 1. The decisions of ORA that rejected the application for asylum of refugees from Grecia is inconsistent with Solaria's international obligation. Thank you, Your Honor. 1. The decision so far as that rejecting the applications of asylum seekers of Grecia is inconsistent with Solaria international obligation and it constitutes an error of law. 2. The decision so far as that rejecting the applications of asylum on the ground of FEGM is constitutes an error of law. 3. The decision so far relating to refugee status determination is constitutes an error of law. 4. The decision so far which authorize the forced return of asylum seekers, including those unaccompanied children, is inconsistent with SOLARIA obligation and it constitutes an error of law. 5. The decision so far which states only refugees who are lawfully staying in SOLARIA are entitled to the right under the 2019 proclamation of SOLARIA constitutes an error of law. 6. The decision so far relating to the standard of treatment is constitutes an error of law. 7. The decision so far which states the comparator group is constitutes an error of law. Thank you, Your Honor.
Thank you. Thank you very much, councillors. You've made your case. The time is for the defendant. You have the same time, 27 minutes. You can allocate your time amongst yourself. And you may introduce your group and then start your presentation.
May it please the court, my name is Jordanus Mecca. Together with my co-counsels, Refugee and Johannes Schmeldes, will be representing the Office of Refugees and Returning Staff there, who will be the defendant in this case. I will be defending the issues of rejection of asylum seekers based on the grounds of female genital mutilation, environmental disaster, and conflict. My co-counsel, Genitalia, will then be doing the issues of group refugee recognition, status determination, and finally exhaustion and cessation of refugees and asylum seekers. Finally, my co-counsel Johannes Schmeldes will be defending the issues of lawful staying as a prerequisite for the enjoyment of different rights and levels of standards. He will also be defending the issues of applicable standard of treatment in addition with the reference group or the comparator group for the most favored national treatment. I will be taking 7 minutes to address my issues, while my co-counsel Bettelheim and my co-counsel Johannes will be doing the same, and we would like to reserve 6 minutes for sub-rebuttal. Thank you. As the facts of the case entail, Soleria has a long tradition of accepting and hosting refugees, and this tradition is there despite the fact that Soleria faces many socio-economic problems of her own. Soleria accepts the majority of her asylums or refugees from the neighboring states of Arcadia, Grecia, and Slovenia. And with regards to the asylum seekers coming from Grecia, Soleria has been forced to only grant complementary protection because around 20,000 asylum seekers have crossed the border in recent time, and it's practically impossible to differentiate among those who have a justifiable ground for their refugee status and those who do not. And with regards to the asylum seekers coming from Grecia, Soleria again has been, my apologies, with the asylum seekers coming from Arcadia, Soleria again has been forced to only grant individualized status determination and halt her group refugee recognition because of the conflict happening in the bordering areas, and Soleria of course has to protect her own national security. Since January 2022, a lot of asylum seekers have been coming to Arcadia from the neighboring states, have been coming to Soleria from the neighboring states of Arcadia because of the conflict happening, and some of these asylum seekers are even coming using stolen cars. In order to control this issue and in order to be cognizant of the public's dismay of how the government of Soleria is dealing with the issues, the government of Soleria has decided to revise its open door refugee policy. At last, Solerian government through ORRA or ORA has also enacted a proclamation or a directive that limits the rights stipulated to refugees under the proclamation, and this is done in order to protect the national interest and the national economy of Soleria. So with this in mind, I'm going to jump straight to the first issue, which is the rejection of asylum seekers based on the grounds of environmental disaster and conflict. We contend that the rejection of asylum seekers based on the grounds I just mentioned are empowered with the law because these asylum seekers do not fall under the 1951 Convention, nor do they fall under the OAU Convention. When we first see the 1951 Convention, first of all, this convention is created for individualized case determination, and this convention does not include those coming in groups, and as the facts of the case entail, these asylum seekers are coming in groups, so they cannot be seen under this convention. But even if they were able to even if they were able to require the Solarian government to look at their cases on an individual basis, they still would not be able to fall under the 1951 Convention because they are unable to meet the two requirements, the two cumulative requirements of fear of persecution, and the fear of persecution being attributable to one of the grounds stated under the Convention, which are nationality, race, religion, belonging to a particular social group, and having a particular political opinion. I would also like to mention the New York Declaration, which Solaria has voted in favor of. I would also like to mention the New York Declaration, which Solaria has voted in favor of, that states that forced migration is mainly caused by environmental disasters, and we want the honorable courts to emphasize on the word migration because there's a big conceptual difference between refugees and migrations. And similarly, the 2018 UN Compact is also an instrument that Solaria has voted in favor of, but these two are just so close and they do not redefine the status of refugee under the international law. Finally, I would like to come to my second point, which is the OAU Convention. The Article 1 sub-Article 2 of the OAU Convention has expanded the term refugee to also include those people fleeing from events that cause serious disruption of public order. Now, when we look at the article, we can see that there are two vague or generic terms, and they are event and public order. And as law of interpretation suggests, if a term is vague, we need to interpret it, and we need to be cognizant of the following points I'm about to mention when doing the interpretation. The first one is the intention of the drafter. As we all know, the OAU was drafted in order to deal with the specific issues of refugee problems happening in Africa, and at the time the drafters wanted to protect refugees coming from other countries due to colonization, so we need to keep this in mind when we interpret this article. Additionally, we also need to be cognizant of the term or the interpretative tool, just generis rule that states that if a general term comes after a specific term, that generic term should be interpreted in line or in part with that specific term. And in this case, when we look at the instances mentioned under that article, they all denote to a man-made disaster, man-made external disaster, and this shows us that natural disasters, like environmental disasters, were not meant to be included under the OAU Convention. Therefore, we interpret the term event to only mean that of involving a man-made attack or disaster, and that man-made attack must also have an international nature, because when we see the intention of the drafters, that's how they drafted it at that time. Therefore, we conclude that environmental asylum seekers and refugees based on the grounds of, or those fleeing conflict, do not have a justifiable ground under the OAU or the 1951 Convention. Thus, the rejection is in par with the law. The second issue I'm going to be mentioning is the rejection of asylum seekers based on the grounds of female genital mutilation. We argue that this rejection is correct because, as we can see from the 1951 Convention and similarly or consequently the proclamation of Solaria, there are some cumulative terms that need to be met in order to say that a person can be granted the status of a refugee, and one of the terms is fear of persecution, and the other is the fact that that fear of persecution must be attributable to some grounds already provided under the instruments. The esteemed applicant mentioned that we argued or we think or we contended that this people fleeing from female genital mutilation do not fit into a particular social group, but that's not what we said. We believe that they might be able to fit in a particular social group, but still they would not be able to gain the protection under the convention because there are two cumulative requirements, and one of the cumulative requirements, which is fear of persecution, is not met in this case. Well, the reason why we say there is no fear of persecution is because first there's a reallocation option or internal flight alternative available to this asylum seekers, and the UNHCR guideline or female genital mutilation suggests that you first must exhaust your domestic remedies and your internal flight alternatives before crossing international borders and asking for international protection. Additionally, we would also like to mention that the government is not proved to be unwilling or unable to protect its female and girls. And if this female genital mutilation escaping asylum seekers are unable to show us that the government is unwilling or unable to protect them, we do not believe that the government of Somalia must be required to give them international protection, and this is why we contend that the rejection of those asylum seekers is in part with the law. My co-counsel,
May I ask a question before we may sit down? What is the basis of the UNHCR guideline to be used in this page?
Well, that's a great concern because the guideline is not binding, but as we all know, if something is vague, we need to interpret it, and UNHCR is an expert in the area of refugees, so we wanted to cite that opinion because they know more about the issues of refugee, and we can use this, as the name suggests, as a guide. It's not binding, but we can use it as a guide.
Was there any instance, any time that this guideline was used by tribunals in the past?
I'm not sure.
Honorable Court, presiding judges, and esteemed applicants, may it please to the Court, my name is Bethaline Gaitana, and today I am appearing in front of this Honorable Court representing the respondent, that is Ora. In the coming minutes, I'll be trying to present arguments to refute the claim that the Solarian government has committed fundamental error of law as to the issues of the group status determination, refugee status determination procedures, principle of non-refoulement, exclusion clause, and also the application of cessation clause by the ORA. If the court allows, I will proceed with the first issue of refugee status determination, and we argue that the Solarian government shouldn't be held responsible for the violation of the minimum procedural guarantees stipulated under Article 16, sub 2 of the 2019 Refugee Proclamation, because this obligation is being rendered impossible because of the simmering situations that are happening in the state of Solaria recently. The state of the Solaria, as clearly mentioned under the fact of the case, is expected to provide protection for the average amount of 2,500 asylum seekers on average, as clearly mentioned under the fact of the case, and this has made it this situation has made it impossible for the state of Solaria to give effective implementation for the minimum procedural guarantees that are stipulated under the 2019 Refugee Proclamation, Article 60. And I would also like to respond to the fact that, or the allegation that the Solarian government should be responsible for providing legal counsel to the asylum seekers. This is against the spirit of the Article 16, sub 2 of the 2019 Refugee Proclamation, because the 2019 Refugee Proclamation provides for the right for asylum seekers to get legal assistance in accordance with Ethiopian laws, in accordance with the Solarian laws. And as per the Federal Democratic Republic of Solaria Constitution, Article 20, sub 5, the right to legal counsel is only reserved for accused persons. As a result, refugees cannot claim the right to get counsel because this is not a right extended for them. As well as I would like also to mention this international principle that impossible obligation is no obligation, because the Solarian government was supposed to get helping assistance as per the principle of the international cooperation from international donors, partners, and also western part of the government. But these partners of the Solarian government has failed on their obligation of the assisting the Solarian government in effective realization of the rights of the asylum. As a result, the Solarian government shouldn't be held responsible because this obligation is being rendered impossible because of the highest number of internally displaced persons that the Solarian government is hosting, and also the previous asylum seekers that are within the territory of the Solaria. We would love also to argue that the Solarian government's obligation or obliging the Solarian government to accept asylum seekers to the state of the Solaria would restrict and also would render ineffective for existing refugees that are within the territory of the Solaria, because the Solarian government, as I constantly mentioned, doesn't have resources in order to provide effective rights for asylum seekers, and obliging the Solarian government in order to accept more asylum seekers would restrict the already existing refugees' rights. And if the court allows, I may proceed to the second issue, which is issue of the group status determination. And we argue that the Solarian government's discontinuance of the group status determination is in accordance with the law, as the Solarian government, and more specifically ORA, is authorized by the law in order to discontinue the group status determination that it accords to asylum seekers whenever it sees reasonable grounds. And the esteemed applicant has failed to show the fact that there is an emergency situation within the state of the Arcadia that necessitates the government of the Solaria to accord group status determination for asylum seekers from Arcadia. In such absence of the emergency situations, the Solarian government should be held responsible to provide group status determination for asylum seekers of the Arcadia because it has still maintained the individual status determination for asylum seekers from Arcadia. And if the court has found my point is clear, I will proceed to the third issue, that is principle of non-refoulement. And honorable judge, we are of the opinion and we argue that the Solarian government didn't violate the principle of non-refoulement. The legal basis for our argument is Article 12, Sub 1 of the 2019 Refugee Proclamation that allows the right for asylum seekers to get protected from being expelled only for recognized refugees. And Article 33, Sub 2 that was mentioned by our esteemed applicants as a basis for the right for asylum seekers to get protection from refoulement is illegal because they are trying to interpret the law against the spirit, because they are trying to legislate and to add new words to the law that is already clear, which only accords the right to get protected from the expulsion for only refugees. And at the legislator side, this in opinion and also had it was a plan of the legislators, they would have used the term asylum seekers instead of refugees. So we argue that the Solarian government should be held responsible for violating principle of non-refoulement because it really deports asylum seekers within its border, and it is only applying restrictive measures throughout the border in order to safeguard its national interest, which is a legitimate sovereign interest that also gets the protection by international laws. And as the court has found my argument is clear, I will proceed to the fourth issue of the cessation clause. And the Solarian government has cessed providing refugee recognition for asylum seekers coming from Arcadia because of the change of the fundamental circumstances within the Arcadian government and within the Arcadian territory, as mentioned explicitly under the status of deputies. And the Solarian government can secede recognition for asylum seekers if the fundamental circumstances within their origin state has seceded, and the Solarian government has exercised this right explicitly mentioned under Article 9, Sub 1, Sub E of the 2019 Refugee Proclamation, and also the 9th Refugee Convention and the OU Refugee Convention as well. And since the objective circumstances under the Arcadia, due to the coming into power of the new government and also the positive measures taken by the new government as to the liberal rights for us, the citizens, and also promising in favor of the free and fair election, allows the Solarian government to succeed giving recognition for asylum seekers. And I'll be finally addressing the issue of the exclusion. As mentioned under the fact of the case, the Solarian government has stopped giving recognition. It has excluded the 20 asylum seekers from Arcadia that have stolen the car and also forcibly entered into the border of the Solaria, and this justifies the Solarian government's act of excluding them because it falls under the non-political serious crimes. And Honorable Court, if you allow, we would love to use the national legal system, and also we would love to invoke Article 669, Sub 3, Sub A of the Criminal Code of the Government of the Solaria that designates the act of being a member of a group and also committing a theft against the property constitutes of an aggravated theft, and this constitutes a serious criminal act, and the Solarian government is as well, as a result of this fact, is allowed to exclude asylum seekers from excluding asylum seekers from the refugee sites. And if the court has no issues, I would like to proceed. I would like to give the speech for my co-counsel.
May it please the court. My name is Johannes Schumanns, and I will be addressing the issues of lawful staying, the standard of treatment, and lastly, proper referencing. With regards to lawful staying, the decision of ORA clearly states that lawful staying is a precondition to the entitlement to 2019 proclamation is correct and not erroneous on the following counters. Firstly, the denial is not absolute denial, as clearly indicated on the case fact on the paragraph 8. as clearly indicated on the paragraph 12, most rights will be given to the refugees on the basis of lawful stay. Therefore, most rights, the term most rights clearly shows that ORA didn't violate and deviate absolutely the entitlements of 2019 proclamation entitlements from the attachment level of refugees. Therefore, we ask the Honorable Court to consider that based on different level of attachments by physical presence or lawful presence, the rights like the right to religion and the like rights will not be taken away. The other thing is the state of Somalia has also a discretion to decide what lawful and not lawful presence. As clearly indicated in the case of Seriousness versus Sweden, Human Rights Committee of United Nations body clearly stipulates that the states has a discretion to decide what lawful presence and what lawful staying is. Based on this classification, the state of Somalia can extend different entitlements based on different level of entitlements. Therefore, lawful staying precondition, which is stated by state of Somalia, is on par with this principle. With regards to standard of treatment, we ask the Honorable Court that a standard of treatment shall not be most favored national treatment on the following grounds. First, most favored national treatment relationship is not established between foreign nationals of Somalian origin and state of Somalia. Foreign nationals of Somalian origin is entitled to this entitlements based on their political relationship with the state of Somalia, and we ask the Honorable Court to extend one.
Okay. Use this 1 minute and we talk about it.
There is no most favored national standard relationship between the state of Somalia and foreign nationals of Somalian origin on the counts of Article 17, sub 1 of the UN Refugee Convention. This provision is clearly interpreted by the official commentary of UN Refugee Convention, which clearly stipulates that reciprocity is required to establish most favored national relationship. However, in the case of that, there is not the case of reciprocity, but rather it is the case of blood relationship between the state of Somalia and foreign nationals of Somalia. And practically, it's also impossible to extend the entitlements given to foreign nationals of Somalia origin to refugees, because the entitlements given to foreign nationals of Somalia origin is.
You'll be granted 1 minute actually to go to your reliefs. I think that's the better way to do it.
Therefore, we ask the Honorable Court, most favored national standard treatment shall not be given refugees, which is given to foreign nationals of Somalian origin. With regards to the comparator group, we ask the Honorable Court that foreign nationals of Somalian origin cannot be used as a comparator group, since there is no most favored national treatment relationship between foreign nationals of Somalian origin and state of Somalia. The policy objective of diaspora proclamation also doesn't support this. It gives preferences to foreign nationals of Somalian origin on the basis of to strengthen their services, their motherland. Therefore, we ask the Honorable Court the following release. One, the environmental disaster, conflict, and the FGM fleeing asylum seekers from the state of Russia doesn't justify asylum seekers, and we ask the Honorable Court not to extend to them.
Now, thank you, councillors on both sides. We give your initial submissions. Now the time for your rebuttal. Both parties have reserved the time, I think. How many minutes are reserved for the applicants? How many minutes? 5 minutes. You have 5 minutes.
Honorable Court, before we are going to our rebuttal point, we have an objection relating to the suit that brought by the respectful counsel of ORA.
Okay, that's the objection.
Thank you, Honorable Court. The respectful lawyers of ORA states that the Somalian government has not a resource repeatedly, but this fact is out of the fact sheet, and it is a mere assumed fact. So those lawyers out of the fact and assume a fact.
Yeah, we might follow that, but still that can be raised in your rebuttal. We consider it as your rebuttal, and you can proceed with the rebuttal.
We would like to have some minutes for this. We would like to discuss.
With the rebuttal?
Yes.
Okay, how many minutes?
10 seconds.
10 seconds.
Yes.
We're going to use this for your 5 minutes. Would you mind if you do that?
Okay.
Okay, you said 6 minutes. Seconds like that.
Thank you, Honorable Court, Honorable Judge, Your Excellencies. In relation to the first issue, that is the expected lawyer for the respondent state has stated that they have admitted that there is fear of persecution, but there is no any persecution. However, the persecution is a violation to universally recognized human right. And the foreigner was, as seen from the case, was being mutilated, and her human rights was being affected. In relation to the events seriously disturbing the public, they have stated that it should be interpreted in relation to the purpose of the OU Convention. However, the drafters enacted this term intentionally, and it's a safety net. It serves as a safety net to include all other events. In relation to the refugee, they say that the girls from Greece have to exhaust domestic remedies. However, the much of Greece was underwater, and they could move to any place of Greece. And in relation to the minimal procedural guarantee, they stated that state of Solaria could not give minimal procedural guarantee because it was burdensome for them. Also, they stated that refugees don't have legal assistance; they don't have the right to legal assistance. However, since a well-known reality that they have legal assistance, they have the right to legal assistance, plus they have the legal right to interpretation, since their language may be different than that of the host state. And in relation to
on the legal assistance aspect, can you elaborate? What law gives them the legal assistance right in issue? I understand the interpretation aspect, but the other aspects of legal assistance, can you elaborate?
Yeah, the 1951 Refugee Convention guarantees them the right to have legal assistance, since they may be persons or a person rather than lawyers.
In accordance with the national law or an absolute right?
It's an absolute right. Yeah. Okay. They have stated that there is, in relation to the MFN treatment, they have stated that it should be, the FNS were given the preferential treatment because of blood relationship. However, this type of fact was not unmentioned, is unmentioned in the facts of the case. So it's not okay. The other is that's it. Thank you, Honorable.
You've done actually.
Yeah.
Thank you very much, Council, for the applicant, for your better submission. The court has already taken note of your ideas. Now it's time for the defendant to proceed with the rebuttal time. How many minutes do you have? 6 minutes. You have 6 minutes. Please proceed with your rebuttal.
Thank you, so Honorable. May I proceed with the rebuttal?
Yes.
Let's start from the first issue, which is the second issue, which is the FEG. Our state applicant clearly states that fear of persecution, there is fear of persecution, but we argue that to say there is fear of persecution in the state of Croatia, the local remedies shall be exhausted first. However, the local remedy is not exhausted first. As clearly indicated on the fact, refugees from Croatia just flee to the state of Somalia, where therefore, since on the situation that since they are not exhausting local remedies, we ask the Honorable Court that there is no fear of persecution in the state of Croatia, because Croatia is a big state. They can relocate from one state, one region, to one region in the state of Somalia. Therefore, we ask the Honorable Court, there is no fear of persecution on this basis.
So the applicants are saying because of the disaster in Croatia, they cannot move to other parts of Croatia.
Yes.
Can you use the conditions in the country of Croatia as a defense for your country's refugee commitments?
Not certainly, but the Honorable Court, we ask the Honorable Court that the still applicants didn't manage to establish nexus dynamics between the two. In the case at hand, there is a nexus dynamics argument raised by different scholars. Since we can raise different scholars' attitude on the Article 38, 30 of ICT. Therefore, since they didn't manage to establish what nexus dynamics is, they cannot simply ask there is natural disaster and there is fear of persecution. The other thing with regards to environmental refugees, we ask the Honorable Court that the environmental refugees from Grecia doesn't justify this definition because it says events, therefore the event is following the terms occupation, foreign aggression, and then which is a term referring to external aggression. Since the proclamation as well as the proclamation is the high copy of OAU, as well as the OAU convention is clearly stipulating and showing the intention of the legislator that the convention is issued for the proper implementation of refugee protection from external aggressors in quote unquote, who are colonizers in the case at hand. It cannot be used as a term refugee. Status determination cannot be given to them. Therefore, we ask the Honorable Court that since there is no nexus dynamics between the two, the condition which is FGM cannot be, or female genital mutilation, sorry, the Honorable Court, female genital mutilation cannot be accumulated with Solarian government. The other thing that we want to raise is with regards to lawful staying. Still, our applicants didn't raise what lawful staying entitlement is attachment in the proclamation, however, as well as in the convention. Lawful staying requirement is a precondition to the most attractive rights of the proclamation. Because this, our still applicants didn't manage to establish this. Lawful staying shall not be preconditional with. The other thing that we want to raise is with regards to the objection of our applicants. Shall we address that?
Which objection? The objection, okay. Let's proceed.
Solaria has a high number of IUP and health unemployment, which is clearly stipulated on the fact. Therefore, it's not a fact that we assume. Therefore, it's clearly stipulated on the fact of the case. And the other thing that we want to address is with regards to most severe national standard of treatment. Since the most severe national standard of treatment given to Messianians as well as for those who are foreign nationals of Solarian origin, our still applicants didn't manage to establish what is there is most severe national standard treatment relationship between the state of Somalia and foreign nationals of Somalian origin. They cannot manage to establish it. With regards to Messianian entitlement, which is clearly indicated under Article 26, Sub 2, with regards to self-employment, our skilled applicants clearly stipulated that all entitlements shall be treated with regards to the standard of treatment, which is most severe national treatment. However, it's not the case. The proclamation in different parts of the proclamation is clear that rights are attached with level of attachment, level of standard of treatment. The level of standard of treatment given to self-employment, which is given to Messianians, is asked to self-employment. Therefore, the self-employment issues shall be raised. However, it's clearly indicated under Article 18 of UN Refugee Convention that with regards to self-employment, most severe national standard treatment cannot be used. Only treatment which is given to foreigners generally can be an instrument or a standard of treatment. Therefore, we ask the Honorable Court, all of the defenses which is raised by our applicants, esteemed applicants, is not in line with the motion of the proclamation. Thank you.
Thank you very much, Councillor, for the applicant and for the defendant of it. I think the court has heard your cases, your rebuttals. We've already taken note of your memorials already. Now the court's going to be in session for the next 15 minutes and come back and raise question of the court.
All stand.
Please be seated. Please be seated.
Okay, the first and frame question was after the applicant and the defendant. Some of the questions are going to be for both of you to answer them, and some of them are going to be addressed to you guys specifically on your cases. So when the questions are asked, we're going to use any order that the question has been posed. So don't expect the same procedure that we've been using for the past 3 days, I think, which is one part to receive the question and going to the other. So we'll start the question, and then we follow the procedure quickly.
Okay, my question actually is applicable to both the applicant as well as the respondent, and it pertains to the issue of fundamental change that you have raised in your arguments. For instance, the applicant has raised that there is no fundamental change in Arcadia to return the refugees to the decision by Solaria to return the refugees to Arcadia. So there is an issue of is there a fundamental change in that country or not. So I think I need more elaboration regarding the factors that you indicated to say that there is no fundamental change. So the government of Solaria is not entitled to invoke this principle that if there is a fundamental change, it can return the refugees to Arcadia. The same question is applicable to you also, because there has to be a process to verify, there is a fundamental change in Arcadia to invoke this right of the Solarian government, to return these Arcadian refugees to their country. So I think you need to elaborate on the process that was followed to verify that there is fundamental change in Arcadia, so that the government is able to invoke this convention article and also the national proclamation to decide on the return of these Arcadian refugees. So there has to be some criteria that has to be fulfilled to verify that there is fundamental change in Arcadia, so that the government can take these kind of measures. So I need also more elaboration on the process that you followed and the involvement of also some stakeholders in the verification process, because there is a requirement that there has to be some key stakeholders that has to be involved in the verification process. So you need to address this issue and more elaboration on that. And also on your part also you have to deal with this issue. I need more elaboration on that. You can start.
Thank you, Your Excellencies. In order to address the question, we need to refer to the additional part that's given to us. That is, the newly inaugurated government promised to implement extensive electoral reforms in the country and also facilitate free and fair election in Arcadia's question. And this is stating that there is a promise. However, there are no practical steps taken by the Arcadian government. This can be, for instance, fair and free election. Also, with regard to the judiciary, independent judiciary, these are some of the practical steps that should have been taken by the newly inaugurated Arcadian government. However, this mere promise may be broken as it's seen practically that most governments, when they come to power, they just give the promise and they'll break it. So it needs to be supplemented by practical steps, as I've stated.
May I proceed, Your Honor? May I proceed, Your Honor? I will be trying to address a question presented from the respected judge. one game, and of course there are certain procedural requirements that are supposed to be followed from the side of ORA in order to decide whether the circumstances that have resulted the fundamental or like well-founded fear of persecution has succeeded within the state of the Arcadia, and there is no internationally established binding procedure as to that, but the UNHCR, as per its interpretive power, has provided for the circumstances that must be considered whenever countries are trying to provide cessation clauses as to the certain refugees, and the UNHCR guideline on the cessation clause clearly provides that, and also it is also explicitly mentioned under Article 1 sub C sub 5 of the 1951 Refugee Convention in 1992 of the 2019 Refugee Proclamation that there must be the fundamental or like the circumstance within the state of the Arcadia should cease that caused the well-founded fear of the persecution. And as we could see from state practice during the Cold War times, the UNHCR, as per its mandate of assisting the states in order for the better implementation of the 1951 Convention and its supplementing protocol, it has given its advisory opinion as to how the states are going to succeed giving recognition for asylum seekers. And during the end of the Cold War, regime changes were taken as fundamental changes by the UNHCR in order to justify the cessation of the status determination or like refugee status for asylum seekers, and as clearly mentioned under the fact of the case that there is a regime change within the Arcadia. And it is not only a regime change, but the government of Arcadia is also undertaking this and also positive, it has pledged in order to take positive measures as to the respect and also granting more liberal rights for its citizens and also conducting free and fair election. And this by itself should suffice, because the government, as a newly established government, is taking a step in order for better realization of the rights of its citizens. A fundamental change of circumstances within the state of origin shouldn't be only taken as a profound change or substantial change, because such kind of changes are practically kind of hard to achieve within a given period of time. And our esteemed applicants have also failed to prove or like to show the fact that there is a compelling circumstance that makes asylum seekers in order to claim against the cessation clause, and also they couldn't establish the fact that the current conflict that is happening within the state of Arcadia is also the one that has happened before, but during the coming into power of the new government. And the previous conflict that has resulted in cessation procedure by the ORA is a result of the fact that the new government has come to power, and nearly 10 months have passed, and the Salvadoran government, more specifically ORA, has decided on that issue after seeing the positive pledges taken by the government as to a free and fair election, and it has assumed that it has taken this with good faith. It has taken this assumption that the Arcadian government is going to undergo constitutional changes that are going to grant citizens with that is going to allow citizens to enjoy their full rights, and that's why the ORA has decided, because fundamental change of circumstances doesn't have to be profound. It could be incremental changes based on the pledges of the government. And that is what justified the decision from the side of the ORA as well as the Salvadoran government. Thank you.
If it is a question from the court, we have an objection.
This is question session.
Yeah. Okay, it's a procedural objection. That's like procedural error.
Okay, where
By the rules of procedural objections can be raised after the conclusion of pleading. Saying we have already come to legal times and legal arguments. It's not the state to raise objections.
Okay, thank you.
Yeah. You may disagree with the answers, but procedurally, what was the problem? Anyways, yes.
I think the cerebral session has passed, and the respondent side has been criticizing our stand in relation to the question.
Oh, okay. The court has taken note of that. We already evaluated the answers for the question.
Thank you.
Okay. Okay. We will proceed with the questioning, but we're not going to set times actually for your answer, but try to limit your answer to reasonable time. Okay? Take note of that. Judge Mizani will proceed with the question.
Thank you. So I have two questions. First, exclusively to the respondents and the other question for the respondents. So my first question, respondents have submitted that people that are victims of climate change and have a trait of refugee and do not qualify as refugees, even under the 1969 OAU Refugee Convention. So my question is, if these kind of people do not benefit from international protection under the OAU Refugee Convention, what do you think is the difference between the OAU Refugee Convention and the 1951 Convention in terms of scope of the definition of refugees? You may answer this question.
May it please the court, just for further clarification, can you repeat the question as to, are you referring to the climate migrants or those asylum seekers fleeing from female genital mutilation? Are you referring to the asylum seekers fleeing from the environmental disaster, or are you're referring to them?
Yeah. And talk about the rate of FGM.
So with regards, I'll first address the question of those who are fleeing from Genitalia based on the fear of female genital mutilation. The reason why they cannot be included under the 1951 Convention is because there are cumulative requirements that need to be met. Even though women belong to a particular social group, these victims or potential victims of female genital mutilation do not pass the taste of fear of persecution, because for a person to say that I have a fear of persecution in my country, he must first prove that there is no internal flight or location, or he cannot access national protection, because one of the rules of refugee law is you cannot ask for international protection if you have the option of asking for national protection. The second question with regards to climate migrants, I'll refer to them as climate migrants because I do not think that there's an international consensus on the word climate refugees, because there's a difference between refugees and migrants, and we do not think that the term refugee can expand to those fleeing from environmental disasters. And the question was, I believe, how is the 1969 OAU Convention different from that of the 1951 Convention? And the main difference comes during the 1951 Convention mainly deals with individualized and political attacks based on the grounds of 5 nationality, religion, race, and having a political opinion or belonging to a certain social group. And a person, in order to be able to be included under the 1951 Convention, needs to be able to show that there's fear of persecution based on one of those grounds. But the OAU Convention has expanded that definition to also include two groups fleeing from events that cause serious public disruption, or that causes a serious public destruction. Yes, but what we wanted to mention is that that serious disruption of public order must be man-made, and it also must have a nature of international conflict. So that's how they differ. The OAU basically expanded the definition.
Okay, thank you. Maybe a follow-up question. Is there any use to can support your submission, saying that that event should exclusively be man-made?
Yes, what we will use to support this contention is the fact that two vague terms are used under the OAU Convention. The terms events is not specified, and the other term is public order. And it's a known interpretation rule that if something is vague or generic, you need to use different interpretative tools in order to interpret it. And we chose to use the intention of the legislator and also the justum generis rule of interpretation to sort of break down where the intention of the OAU Convention is in terms of protecting asylum seekers.
As I said, my second question was to the applicants in the respondents. Both parties did not mention the relevance of reservation in their submissions. But if we look at the fact of the case, particularly paragraph 1, it mentions that the state of Solaria has entered into reservation in ratifying the 1951 United Nations Refugee Convention. And that reservation has not been withdrawn. So what is the implication of that reservation in terms of the submission you make, both for the applicants and the respondents? So the applicants may respond first and then the respondents.
Somalia declare a reservation under Article 17, Sub 1 of the 1951 Refugee Convention. But reciprocally, that concept of the treaty, that means the concept of Article 70, Sub 1 is incorporated under Article 8 of the 2019 Refugee Proclamation of Somalia. That means reciprocally, Somalia is bound by the treaty because reciprocally it incorporates the concepts of Article 77, Article 1 of the 1951 Refugee Convention into its national refugee proclamation.
Yes. So the reservation is made on Article 17 sub 2, not sub 1. So if Solaria doesn't make reservation on Article 17 sub 1, what does it mean?
Yes, Solaria make a reservation on Article 17 sub 2.
Yeah, so it didn't make reservation on sub 1, on the first sub-article.
Yeah,
does it make a difference?
Yes, of course.
Okay, can you elaborate?
For instance, in a reservation, Solaria, under Article 17 sub 1, there are 7 grounds. That is 3 years to be completed, that is the child and spouses. On the 2, that is the child and the spouse, Solaria make a reservation. But in the first one, Solaria does not incorporate the term in its article, that is Article 8 of the 2019 Refugee Proclamation. So, Solaria is bound by that treaty, that is somewhat.
The Council, you did not clarify the implications of the provision of the 2019 Refugee Proclamation. So, you said that the spirit of Article 17 is incorporating the proclamation. So, what does that mean in terms of legal procedure?
Thank you, Honorable Report. Can we discuss this with the Councillor to clarify the question?
Yeah. Half a minute. Your time is up. You may proceed with your answer.
Under Article 17 of the 1951 Refugee Convention, Solaria, as we can see from the fact of the case, make or declare a reservation. But in this reservation, Solaria make a reservation only on 2 grounds. That is under sub-article B and sub-article C. That means Solaria is bound by the term under Article 17, sub-article 2, sub-A. That is the condition. If you don't clarify, I will invite Mr.
If it's the permission of the court, I will have some points.
Yes, we've got it. I think the judge has already understood your ideas. We'll take care of we'll take note of the answers.
Thank you.
Yeah, can you proceed with the respondent for the answer to the same question?
Thank you, Your Honor. I'll be addressing a question presented from respected Judge Iswael, and I'll be trying to justify the reservation that the Salvadorian government has made as to Article 9 of the 1951 Refugee Convention, which speaks about provisional measures. And it gives a discretion for state parties to apply provisional measures whenever there is an issue that renders their international obligation impossible, such as the issue of war or like public disturbance. And the Salvadorian government has explained its reservation as to Article 9, that is provisional measures. And with regard to our case at hand, it justifies that the Salvadorian government gives precedence to its national security, and it tries to respect the rights of refugees in a way that wouldn't compromise its national security as well. So whenever there are certain circumstances that are happening either in border countries or within it, which is for this fact of the case, the Salvadorian government is under a high pressure of asylum seekers coming from different parts of the country, and the Salvadorian government hadn't expressed this reservation to this article. It was expected from the international community in order to apply measures that would try to still give recognition for the rights of asylum seekers, but given the high burden of internationally displaced people that it has, the youth unemployment, and also its long-standing tradition of the accepting asylum seekers, which implies that there are already large number of asylum seekers and recognized refugees within the state of the Soul area. The state of the Soul area could invoke national security in order to apply measures in a way that wouldn't compromise the rights of asylum seekers and refugees, of course. So the Salvadorian government could invoke that it's not getting enough assistance, and the current situations are burdening it, and as a result, it couldn't apply the other complementary provisional measures to its state. So the relevance of this reservation as to Article 9 is to relieve the Salvadorian government of its responsibility of being expected from the international community to apply measures whenever it is under situations that render its obligation impossible. And the Salvadorian government could invoke its national security as well as the current internal legal systems and resources that it has whenever its obligation is becoming rendered inapplicable because of the existing situations. Thank you, Your Honor.
May I add something on the Honor Court?
I think she used enough time. Yeah, we'll proceed with Judge Miller.
Okay. Thank you very much. So I have two questions that relate to both groups. So the first one relates to the issue of seriousness. So one of the exclusionary means is that if a serious non-political crime is committed, then that should be used as an exclusion not to give the refugee status to an applicant. And you have been saying that it's not serious, it's petty, it's minor, all these words you have been reading, but how do we know it's minor or petty? So what are the legal basis for classifying this as petty, minor, or serious? So the respondents use the Solarian criminal code to mention that it's a serious one, and what would be your response to that?
Thank you, Your Honor. Regarding the serious non-political crimes, of course, we affirm that the 20 asylum seekers who crashed Solarian border by a stolen car. So here, from the fact, it is inferred that there is no armed robbery because they just stole a parked car and doesn't, take any kinds of violence on individuals or on anybody. So they just take the car to avail themselves from the conflict. So a serious, the term or the exclusion shall be strictly interpreted. So in order, because of this interpretation rule, the or seriousness of non-political crimes cannot fit for this.
Yeah, but the question is, why is theft not serious? So you're just saying this is a theft and it's not robbery or violence. Why is theft not serious? What legal basis do we have to say theft is not serious?
Of course, for this case, we have as I just tried to mention earlier, UDHR paragraph 14, the guideline. Basically, the guideline just stated or seriousness of non-political crimes, and it just excludes theft or a mere theft, which is not incorporated with armed robbery, is just a minor crime and it is not counted as just a serious. And we just use this guideline because it can more pursue our the interpretation, and that's all.
Yeah, thank you.
Further issues?
Thank you very much. So, related question to the respondents would be, you have mentioned the solar and criminal. To be honest, I would like for you to elaborate what that specific provision you mentioned. I thought you mentioned 669 subset, which I'm not sure refers to this kind of cases, but of course, an opportunity for you to explain about that. The other one is this relevant in terms of exclusion in a way that you cannot hear the individual's case, the 20 person's case, and determine that they don't deserve? Because from the case, it seems that they were not even heard about their asylum. And when you look into literature, you will find that the aspect of seriousness must also be interpreted in terms of the balance between the act committed and the fear protection that they are running away, right? So, in terms of striking the balance between what is committed and in terms what they will face if they were to be recruited, then there are some literature that we have considered this particular balance. What is it?
Thank you, respectable Judge Merit. I might have misspelled the article, but that specific article under, I assume it was 669 sub 3 sub A of the Criminal Code, it states that members of a group that commit a crime of theft against the property are going to be considered under the aggravated theft article. So the reason that we have used this article is because of the fact that there is no internationally accepted definition as to what non-political and also serious criminal act is. So the Salvadoran government is not left with any option to determine which law it is going to use in order to determine what non-political serious crime list is. So the Salvadoran government was forced to employ its already existing national legal instrument, that is the Criminal Code of Ethiopia, and in literatures as to, including the UNHCR as to the exclusion clause, they suggest that the number of years of imprisonment could be used as a way in order to justify whether or not it is serious non-political act. So the Salvadoran government has considered those international literatures and also recommendations from international legal scholars and has tried to apply it to its already existing national law. With regard to the question of the right to be heard, isn't it the right to be heard being left by the Salvadoran government? As mentioned under the fact of the case explicitly, the asylum seekers, those 20 asylum seekers from Arcadia have admitted the fact that they have stolen the cars. So they were given the right to be heard, and they have admitted the fact that they stole the cars, and they were just adding after fact to the case, alleging that they have just stolen a parked car and they were just doing it forced because they have no other options. So the right to be heard was respected by the ORA. If that may answer your question.
Yeah, thank you very much. The second question would be, and I will start with the respondents on this, and some of the reflections have been made in terms of your response to the reservation aspect. What was the international support and the obligation of the international community towards supporting refugees in Solara, and how it is related with the obligation of Solara. So as you say, for example, the right to work under the convention is, Ethiopia said, Solara said that it will accept it as a recommendation, not as an obligation. And when that happens, then Solara must do something about it, but the international community must also support it. but some other obligations, and the proclamation of Solaria regarding refugees, it's not a recommendation. It's an obligation which is written under the law. So can we run away from a particular obligation because a country cannot receive an international support? So if the country doesn't receive international, what would be the next move? Changing the proclamation maybe to say that we're not anymore obliged by this particular obligations that we sign in international commitments or through our national laws. But once you have the proclamation which obliges a state to do something, can a lack of international support be a reason to this? Because, as you say, burden sharing has been included in the Global Refugee Compact, it has been included in the 9-place roadmap, it has been included in the CRRF and all these New Year declarations. But what's the relevance of it in terms of a state's responsibility? Yeah.
May please the court. With regards to international cooperation, we addressed in different issues. International cooperation is required for proper implementation of refugee law overall, generally in the world, as well as in national context. With regards to self-employment, the reservation which is made by Solaria as Article 17 sub 2, it cannot be used in this context because, as clearly indicated under Article 17 sub 2 of the Refugee Convention, it's talking about wage earning employment. So this kind of employment which is entitled to foreign nationals of Solarian origin is not denied because of lack of international cooperation. Rather, it's denied based on the preambular statement and the overall objective of Solarian preference-giving proclamation, which is the Atora proclamation, clearly stipulating that the rationale behind extending preferences to foreign nationals of Solarian origin is to strengthen their tie with their motherland, which is firmly Solaria. Therefore, the claim is not international cooperation, in lack of international cooperation, in this case specifically, which is raised by Your Honor. Therefore, we ask the Honorable Court not to see all.
So, if I heard correctly, in your response to the previous, to the claim, actually, you say international cooperation is lacking, so impossible obligation cannot be taken as an obligation. Okay. I just want you to clarify.
Okay. That's related to group status determination. It's related to group status determination. Right. Our claim with regards to group status determination and lack of international cooperation, the guideline of the UNHCR, which is adopted in 2011, clearly also stipulated that there must be international cooperation between the states to implement group status determination as to include those who are coming from different neighboring countries of Solaria. However, we are not raising it as exclusive and sole factor denying right. However, there are different procedural irregularity made by refugees and other things, which is violated by refugees. Therefore, our claim is not only international cooperation law as well, but there are different requirements violated by refugees, and non-fulfillment of these requirements is triggered to consolidate it. Therefore, we use it to consolidate our argument as to bucket. Therefore, it's not only sole factor.
So, any reflections on the questions or the response given by the respondents?
Thank you, Your Honor. In relation to, if I have correctly understood your question, it's in relation to the reservations that Solaria made to Article 17, Sub 2 of the 1951 Refugee Convention. Is that right?
That was not the question.
Okay.
So the question, I mean, in terms of legal analysis,
yes,
the question is, to what extent can lack of international support to Solaria have any significance to the protection of rights of refugees, yes, which Solaria is obliged to based on its national laws and international agreements?
Yeah. Thank you. In relation to burden sharing, normally there are the comprehensive refugee response framework in which states have expressed their willingness to share the burden of the host state in protecting the rights of refugees. However, state of Somalia have requested, have been complaining that the international community have not been supporting its endeavor in protecting refugee rights. But at the same time, it has not been it has not done any affirmative or encouraging step other than just complaining. Other than complaining that the international community have not been providing support. Thus, it should have done in its efforts. It should have exerted great effort to protect the human rights and the rights of refugees. However, it failed to do so. Thus, the respondent state has, in this regard, breached its international refugee obligation.
Yeah, but let's make it a bit specific. So, Solara is saying that I cannot even give jobs to my nationals, let alone to refugees. What do you say?
Thank you, Rona. In this regard, Solara has said that it cannot provide an employment right for its citizens, let alone for the refugees. However, under Article 26 of 2019 Refugee Proclamation, it has stated that it says that refugees should be treated on par with most favored national. And if we check the most favored national, or if we try to define what most favored national treatment is, it is, we can get its definition, we may not be able to get its definition from the 1951 Refugee Convention. However, we can get it from the Travaux Preparatoires of the 1951 Convention, or the commentary of the UN Refugee Convention. It says that most favored national treatment to only be provided between states to reciprocally benefit their nationals. So, in our case, Somalia has this kind of treaty with Messenia. So, if we go in this way, Article 26, if you apply Article 26, they should be treated on par with the Messenian nationals. However, the directive has restricted their rights.
The question is not about comparing with other nationals, but their own nationals. The state of Somalia said that it has a lot of IDPs. There is a high rate of unemployment for its own citizens. So how am I going to be forced to provide employment for refugees while my citizens are unemployed? So it's not about comparators.
Thank you, Hore. Of course, from the fact of the case, Somalia has complained that she have a long, shouldering much of burden in respect of unemployment and IDPs, but we don't argue that policy considerations or the matter of unemployment or those burdens should not be. We're here at the court. We should interpret the laws. So interpretation of the law, or other considerations or prevailing circumstances cannot be a ground to excuse the interpretation of the law. So that's what we have to seek the court. Thank you.
Thank you.
Judge, I cannot proceed with the questioning.
Okay, I will have one question for the applicant side and maybe also one for the respondent. So, for the applicant side, one of the pleadings that you submitted is the state of Somalia has violated its commitment by using a lower comparator group while the proclamation requires refugees to be treated with the most favored nations nationals. The state of Somalia has adopted a proclamation for foreign nationals of Somalian origin based on some internal considerations for investment, for other socio-cultural considerations. The respondent side also said that for blood relationship. And there is also bilateral and multilateral treaties based on reciprocity with the state of Messenia, and the citizens of Messenia are treated better than refugees. So my question is, how do you put a hierarchy of laws among these different laws because there is a proclamation for diasporas, for foreign nationals of Solarian origin, which is a proclamation. So how do you put the status of the refugee proclamation and also the subsequent directives in light of other bilateral and multilateral treaties and other domestic laws, so that you can say that there is a violation of the commitment of treatment of refugees?
Thank you, Your Honor. In relation to this question, yes, Solaria has enacted the FNSO proclamation. It has, of course, has its own policy justifications, but what we need to see here is we are in court of law, and we are not trying to examine what the policy justification behind these laws are. And it says Article 26 of 2019 proclamation affirms refugees and asylum seekers based on most favored national treatment. So, if so,
there is another proclamation parallelly for diasporas.
Yes, the proclamation.
Yeah, proclamation to under 70 on foreign nationals of Solarian origin who are preferred in terms of investment, employment opportunities, work permit, and other things.
Yeah, the FNSO proclamation. Yeah, in relation to the FNSO proclamation, either the most favored national treatment should be via treaty or legislation. So, the most favored national treatment or the refugees must be treated on equal footing with FNSO or otherwise alternatively or at least with mercenary nationals. However, in no way can they be treated on equal footing with the ordinary foreigners. As stated under the facts of the case, they have little, if nothing, preferential rights in Solaria, these ordinary foreigners. So, as per 26 of the 2019 Refugee Proclamation, they must be granted either the FNSO, they must be treated either as FNSO are being treated or the Messenians are. But there is no way that they can be treated with on equal footing with the ordinary foreigners. And to address with the question with the directive and also the convention, in relation to the convention, the proclamation is progressive than that of the convention, and it was actually nominated as one of the most progressive proclamation in Africa. So even though it limits, for instance, under the 1951 convention, it uses terms like as favorable as possible, but not in any way less than that of the foreigners. However, under the proclamation, 2019 proclamation, it states that they must be treated as the most favored national treatment. Plus, the directive has restricted, or it has made it practically impossible for the refugees and asylum seekers to enjoy their rights given to them under the 2019 Refugee Proclamation. So, since
the presence of the proclamation, do you think the directive will hold?
Can you please rephrase?
The presence of the proclamation 2019, there is a directive which is showing the backslide. So, do you think the directive can stand?
No, that's our stand. The directive should not be in any way acceptable, because the directive is in place to implement the proclamation, not to stand in contravention with it. Plus, the directive, the proclamation is superior in the hierarchy than that of the directive. Thus, for these reasons, the directive's stand is should not be accepted. And,
okay. Thank you very much. Yeah. Okay, a question for the respondent side. When asylum seekers were forcefully returned to Arcadia, the applicants pleaded that this is a violation of the principle of non-refoulement. But councillors argue that the principle of non-refoulement does not apply to asylum seekers. What is the legal basis to argue on this? Which international or national legislation excludes asylum seekers not to benefit from the principle of non-refoulement?
Okay, I'll be responding to the question from respectable Judge Aitano. Our legal basis for claiming that principle of non-refoulement only applies for asylum recognized refugees is Article 12(1) of the 2019 Refugee Proclamation that explicitly states that in order to get protection from expulsion, you have to be a recognized refugee. And asylum seekers, as we know, their status determination is not done yet. So they might be people who are, they might be economic migrants, they might be combatants disguising themselves as civilians. So unless a status determination is explicitly and effectively conducted by the Solarian government, it cannot accord protection for asylum seekers because their status is not recognized yet. And other legal basis is Article 33 of the UN Refugee Convention that uses the term refugees. So the term refugee and asylum seekers are different because asylum seekers are people who claim to be well founded fear of persecution, but their status determination is not done yet. However, refugees are those whose status is determined and who have the right to gain protection from non-refoulement, as explicitly said under the law.
So you can just return people at your border. Is that okay?
No, that's not the case, Your Honor. Apologies for interjecting. Our argument was the Solarian government doesn't arbitrarily expels asylum seekers from its territory. As mentioned under the fact of the case, it is only applying restrictive measures throughout the border because the issue of national interest necessitates. And this is a recognized legitimate interest under Article 33 sub 2 of the Refugee Convention because the states can determine whom are they going to allow into their border, because the right to seek asylum is a right, but the right to grant asylum is also a legitimate interest and right of a state. And the state do have a legitimate interest of maintaining its national security and territorial integrity. So because of the case of the fact that Solaria is sharing borders with other states where civil law and also other different kinds of conflicts exist, the legitimate interest of Solarian government has necessitated to apply restrictive measures in a way that wouldn't defeat the overall objective of the Refugee Proclamation and also Convention. So we are only applying restrictive measures throughout the border, and we don't even support arbitrarily allowing asylum seekers to be expelled because that's against the international commitment that the ORA has undertaken.
Council, a follow-up question in relation to the position of Group Organized, the 2019 proclamation, in confining the applicability of the principle of reform to recognize refugees. Is that on par with international your obligation under the 1951 Refugee Convention?
May Your Honor please reread the question for me.
Yeah, the question I'm asking is a legal question actually. A legal question in the sense that you have issued a proclamation which among other things provide the grounds on which reform will be applicable. And you mentioned that it is confined to, its application is confined to recognize refugees, but not others. Is that right?
I didn't get your question, Your Honor.
So, can you clarify?
Okay, yeah. Let me clarify that and also have a follow-up question to that. You seem to argue in your law, it's been stated that the status of refugee is applicable in protection, like which are attendant to protection of refugees, attendant to only refugees. Others are excluded, asylum seeker included. So the question is that law in part with other international obligation that your government has? Is that clear?
Yes, Your Honor.
This is the question, yeah. Okay, a follow-up question to that. You say that you're only taking restrictive measure, but you're reforming actually, turning people back already. So that's not a strict measure in terms of understanding actually. You're reforming these guys who are coming as asylum seekers to your territory. So without the proper understanding or proper procedure of following the application and understanding and helping the asylum seeker to plead their cases before a court of law in a due process, your action of returning these asylum seekers, does that amount to refoulement? Does that make sense? Or is it is it not necessary for the government of Solaria to make sure that asylum seekers are here in a court of law before determining whether they are legal refugees or not, or whether they are entitled to the right of being refugee, and whether they should be reformed actually back to their country?
Okay, I will thank you, Your Honor. I will start responding from the latest question that the Solaria arbitrarily expelling asylum seekers from SS border wouldn't need amount for the violation of the principle of non-refoulement. And our argument is that the Solarian government, as far as it could allow for its resources and also available internal remedies, the Solarian government tries its best to respect the rights of asylum seekers. However, there is this competing interest of the national interest, which is explicitly recognized by the International Convention as well as the 2019 Refugee Proclamation that the state would employ. So the issue of status determination has become almost impossible for the government of the Solaria because, as mentioned under the fact of the case, the Solarian government houses about 707,000 plus as refugees and asylum seekers, and there are also on average basis 2,500 asylum seekers are coming to its borders. So how could the Solarian government could undergo a refugee status determination, even if the Solarian government is of the interest in favor of the recognition of the rights of refugees, which fits with its previous commitments, because the Solarian government has been recognized by the world for being one of the nations for accepting and also housing refugees. The Solarian government's lack of resources in order to undergo individual status determination for asylum seekers made it almost impossible for it to give effective implementation for this obligation. And allowing group status determination, let us say, for asylum seekers from Arcadia would threaten it as national security because combatants who are not afforded protection as per the convention and also the proclamation might take advantage of the refugee system and they might undermine the system in order to escape from justice. So that's why the Solarian government is trying to do, to give precedence first to its national interest, which is also a state practice. We have seen different, the American EU applying restrictive measures throughout the border. It is of course of our interest that the rights of refugees should be respected, but our situation and also resources do not allow to do so. So that the resource limitation and also the current compelling circumstances of a civil war are the ones that are impeding the Solarian government from effectively implementing its obligation. Not it is non-commitment, because this commitment has been proven. It has well track record of the respecting rights of asylum seekers.
Actually, my question was simple and direct. I was trying to compare the proclamation and the 1951 Refugee Convention. So it's basically about the scope of application of the non-reformer. So does that apply to non-recognized refugees?
Yes, it does, because non-refoulement is a right that is only accorded for recognized asylum seekers, not those who seek to get asylum. In the state, the Solarian government is exercising the sovereign power of giving recognition for asylum seekers if they fulfill the definitional requirements. So the Solarian government's principle of non-refoulement, as explicitly mentioned under Article 12, sub 1 of the Refugee Proclamation of the Solaria, this right is only afforded for recognized asylum seekers or refugees. And the Solarian government tries its best to accord asylum seekers, but it still applies restrictive measures for the obvious reason of national interest. So the Solarian government tries to respect the principle of non-refoulement fully for asylum seekers that have formal recognition, and for the case of asylum seekers who might be refugees, it tries to respect their rights as per its available resources. Did that answer your question?
I think it's really satisfied. Really satisfied with your answer. Thank you. I'll proceed to the applicant with one question. Okay, thank you. So one explanatory question, actually, the last question. You seem to read some principles from international jurisprudence and principles from international experiences, including cases. One of the famous cases on your annex as well is Fanna versus the Secretary of State for Home Department. Now our question was that what's the legal basis for you guys to raise this foreign jurisprudence, and what purpose do you want to achieve with it? What do you want us to learn from the case? Thank you.
Thank you, Honors. Of course, we have tried to mention some cases and scholarly writings, but the thing is, our reference is Article 38 of the ICG, which states that it's called famous scholars' rights.
Sorry, Councillor. This is a domestic case. You brought your case to Solana Supreme Court, so the ICG statute will not apply to this case. Yeah. So the court is not bound to use the sources of error provided under the ICG statute.
Of course.
So limit your answer to domestic use, or talk to one another. Talk to one another. So give her answer. She started.
Let's discuss it.
You've discussed it and give it her to answer, please.
Thank you, Your Honor, but we were trying to just to change the question and we didn't discuss it.
I have allowed you to talk about it and answer.
Okay,
Yes.
okay.
So talk about it and answer. You talked for the last how many minutes?
Okay.
Thank you.
Thank you.
Okay. So 1 minute.
All right, sir. Your Honors. I think that we just use those case laws or scholarly laws because they are persuasive to pursue our ideas, and also they are subsidiary laws. Okay, there are different sources in the international law, and these scholarly writings and cases are subsidiary laws which can pursue for more interpretation and when there is a vagueness or ambiguity and cases of interpretation.
Thank you, Councillor. I think the court has finalized the question. You may sit it.
Thank you.
Yeah. So you heard your answers and your application, and then you read your memorial. Now the court is going to evaluate your arguments, evidence, and everything you presented, and pass judgment on the case that's brought before it. For that, the court has been adjourned now.
All rise.
And then we will announce the second runner-up is already on, and then we'll announce the first runner-up, and then we'll announce the winner of the competition. And the judges have chosen Murata to represent them, so Murata will be giving the award and he will be giving the speech when it comes to the winner round. So the best memorial goes to Alabama University. Next up is Best Oralist. Best Oralist goes to Moot. Second runner-up is RC University.
First runner-up is Moot University. And the winner of the National Refugee Law Moot Court competition is Asylum.